It's shit in the south.
Добрий день, пане Ярославе. Bачите, чуєте?
Good afternoon, Yaroslav. Can you see and hear us? Yes, but not quite in good quality. Do you mean that there are some problems with the image or with the sound? Well, I can see you, but to tell the truth, I cannot hear you well enough. I don't know whether this is a problem about my gadget or about your gadget. Delayed signal. Well, that could be the case. What happens with delayed signal? Okay, so anyway, I'm ready. So welcome at the second stage of the selection to the High Qualification Commission of Judges of Ukraine. Here is the selection commission, all members of it present. Let me introduce ourselves. These are Yevhen Mezhnitsov, me, Ivan Mishenko, Stephen Markman, Serhiy Verlanov, Ted Zajachny, Robert Brookhuizen. The rapporteurs at your interview are Stephen Markman and me, Ivan Mishenko. So if for any reason the interview is interrupted due to bad connection or in case of air alarm, or if there appears to be any other technical issue, we will agree with you on the time and date when we will resume the interview, starting with the place when it was interrupted. Please give concise and clear answers to the core of the matter, and the member of the commission asking you a question shall be entitled to limit the duration of your answer. And before the beginning of the interview, you will have a chance to present yourself, to tell about your motivation for applying for this competition, to tell about your ideas and the key things you would like to share with the selection commission members. So I think that we may start. And let me give the floor to my colleague, Stephen. Stephen, the floor is yours.
Thank you, Mr. Chairman. And of course, thank you, Mr. Dukh, for your participation. We look forward to having an opportunity to speak with you and learn more about your background and your interest in this position. At the outset, though, we would like to give you up to 5 minutes to speak generally, to introduce yourself to the Commission and people who are watching, and perhaps to explain further your motivations or anything else that you think deserves emphasis. So why don't you please proceed? Thank you.
Thank you. Good afternoon. So I'm a lawyer with 25 years of background in the field of law, and since 1998 I worked for 8 years in the local prosecutor's office as assistant prosecutor and investigator of the prosecutor's office, and I supported public prosecution, and there were 300 sentences passed with my participation, and I was also a juvenile prosecutor and senior assistant. I worked as the investigator, and I sent about 30 criminal proceedings in which later sentences were passed. I worked for 10 years as the investigator in the prosecutor's office, in the General Prosecutor's Office, and there I protected financial economic interests of the state, followed compliance with the laws of administrative offenses, in particular compliance with the law on corruption prevention, and I represented the prosecutors' bodies in the High Administrative Court. Besides that, while I worked in the General Prosecutor's Office, I had the mandate and the duty to consider the regulatory norms that were submitted to the Cabinet of Ministers, and to also work with other issues. Then I was mobilized to the army in 2015, and after demobilization in 2016, I participated in the selection, on the basis of which I was elected detective of the National Anti-Corruption Bureau of Ukraine. Until 2020, I worked as a detective and had investigated criminal proceedings concerning MPs and heads of state enterprises, in particular illegal enrichment and declaration of deliberately false information. Then I worked in the National Agency for Corruption Prevention, where I was the head of the Department of Internal Control and had some other position. Over the period of my work in the National Agency for Corruption Prevention, I also worked with regulatory norms and acts that were developed by this body and prepared those acts by myself, in particular the regulation on the procedure for holding integrity checks. And further on, we started this activity, the verifications. Also, my unit analyzed the risks of the activity of the national agency as the budget holder. I was also involved in the activity of the selection commission of the national agency, and on the basis of the results of the meetings at which I participated, we recommended more than 100 staff members of the national agency for appointment. I took a lot of actions related to anti-corruption, both in cases of gross corruption and minor corruption. Well, I think that that's it. Concerning my motivation, I think that I will speak on that while answering your questions. And also I would like to mention that when I was preparing my motivation letter, unfortunately, I didn't have enough chances to go deep into the problems of the judicial reform that are more relevant now. So I will be explaining my points and my motivation while answering your questions. Thank you. And I think that my experience is going to be of use if you decide that I should be recommended for the HQCJ. Thank you.
Thank you very much, Mr. Duke. We're obviously aware of your current service in the armed forces of Ukraine, but I think we're also aware that this is the second time you've been involved in that, and your country owes you a great debt, as does much of the world. So thank you for what you've been doing. Not that your work as a prosecutor hasn't been a great public benefit too, but it's very special what you've been doing in the military. Reading your motivation letter, Mr. Duke, of course, our attention was captured in your first paragraph where you say that I believe that the court, as the highest form of state control, should be on the same side as your interest and the prosecutor's interest, but mostly it was otherwise. What do you mean by that? You're not going to win them all in the court, are you? Could you hear my question, sir?
Yes, I've heard your question. I think that the state should guarantee law and order throughout the country. Law enforcement bodies are bodies of the prosecution gather and collect the materials, but the final assessment and the opportunity of using these materials and passing the final decision is passed by court. So I think that all our work should be directed at completion of materials for the court, and the court passes the final decision. So we all work in the same direction.
But you say that the court should have been on the same side, but mostly it was not. Can you explain that experience and what it caused you to think about with regard to the judiciary? Was this an impetus for you pursuing this position?
Yes, I've got the question. Thank you. The point is that since I worked for a long period of time in the prosecutor's office and in law enforcement bodies, I really faced the cases of non-impartial actions of the law enforcement bodies, and I fully realized that the judicial control is the most adequate way to assess the actions of the bodies that have a rather high mandate and that can pass some preliminary decisions on the assessment of legitimacy of actions of citizens and other bodies. That's why I realized that it is judicial control and judicial consideration that is the highest form of assessment of our work as for today.
So to make sure that I understand you, there are, of course, cases that you as a prosecutor lost, but there were also cases that you as a prosecutor lost and felt that the court was not treating your side fairly. Is that correct?
Yes, you are right. There have been different cases, and there have been cases like the ones that you have mentioned.
And what is it that you think needs to be done about this? Obviously, no side is going to win every case. There's a winner and a loser in every case, and the losing side is always disappointed. But hopefully the losing side will understand that the rule of law has been applied and it's treated them fairly. But what do you do about those cases in which you feel that something more was happening?
Well, in fact, the state doesn't have the opportunity to address the European Court of Human Rights like citizens have. So the state can only try and develop better judicial stuff, hope that the judiciary will work in the interest of the state and the citizens, in the interest of the prosecution and of the defendant, and that it will work in the interest of all the parties within all courts of all jurisdictions.
Am I wrong in saying that the court should work not in favor of the interest of a particular party, but in the interest of the rule of law?
100%. That's true. Only on the basis of the rule of law and in the interest of it.
Okay, and that was part of your motivation, as I understand it, for applying for this selective competition. Is that correct?
Right, you are. Yes, so thank you for helping me to share my motivation right now.
No, your motivation was clear, and that's why I think I understand it. Having applied for this position and perhaps being successful in this competition, what do you hope to do if you're placed upon the High Qualification Commission? Your motivation is extremely straightforward, and I think we understand it. Perhaps it's less clear what you intend to do in pursuit of your motivation if you're placed upon the commission. Could you share some perspectives on that, please?
Just a minimum remark. Let me stress that I came to the National Agency for Corruption Prevention in 2020 at the beginning when this the operation of this body was actually reloaded, and the former composition of the agency had been criticized. And I joined the team that actually did this reloading, and there was an assessment of the body and of each staff member. A new regulatory basis was developed that ensured activity of this body and transparent processes, which have been assessed adequately by the civil society. So I'm sure that I can join the same reloading, relaunching process for the HQCJ, that I could be involved in the development of the team and implementation of the tools of inobsessive but ongoing control, in particular as far as access to information and disposal of information is concerned, because I think that it is really important to ensure confidentiality of information, in particular for judicial candidates or for judges, incumbent judges. And I would also like to join in the development of the new regulatory framework and in ensuring the transparency of the new selection processes and assessment of judges.
But on the first day of the new High Qualifications Commission, I would guess there will be few people on that commission. Among the 16, there will be few people on that commission, other than maybe a couple of judges, who have more experience in the courtroom than you, who have more familiarity with the criminal justice system in particular than do you. What are you going to be sharing? What observations and insights and counsel are you going to be sharing with your colleagues who lack that tremendous degree of perspective?
I've got some experience of working in younger staff. I used to be the oldest person in the unit where I worked in the National Anti-Corruption Bureau of Ukraine, and that was always also a team of people who belonged to different fields of activity. I had only 2 people in my unit who had some experience of working in the prosecutor's office before that. They all had different qualifications, but anyway, we were all united by integrity as a criterion. So I think that I'm sure that all members of the HQCJ share the principles of integrity. That's why I'm sure that it will be easy for us to come to a consensus. And as far as priorities are concerned, these priorities are well stated. You keep stressing as a selection commission on the priorities of the HQCJ's operation. These are definitely making of the selection of judicial candidates and judges, and qualification assessment, of course.
Well, of course, it's good to hear you talk about the team. I've known many prosecutors over the years, and some don't work as well on a team as others do. It's good to hear you talk about that team. At the same time, you're a very special individual with a very special background, and I'd like to know what kind of difference you'd like to make with that team. How would you like to provide guidance to the team that you're going to be working with?
Well, I think that there will be 16 members, but we will also have to develop the team of inspectors to help us and the Commission staff. For some period of time, the Commission has not been operating, so we will need to assess whether people who become members of the HQCJ will be able to perform their duties. And another important direction is access to databases. Now we have 16 registries in the state that must be provided with information, and access should be provided to those databases for the HQCJ. I was partially involved in ensuring access to those databases for the National Agency of Corruption Prevention. And I would like to ensure development of some system of internal control at the first stage. And since I've been dealing with such procedures, so I could help here. And since I have the corresponding background, I could also help develop some internal rules, internal regulations, and share the practices that I consider to be relevant and high-quality ones.
But when you serve on the High Qualifications Commission, you will bear in mind those judges in whose courtrooms you've been, who have not been entirely fair and neutral in dealing with the rule of law, will you not?
No, I think no. It seems to me that I am rather objective in my treatment of judges. And since I've been working in this environment for quite a period of time, I know different examples of treatment of their work by judges. And I think that most of the judges are good professionals and people of integrity. So I think that in our judiciary, misdemeanor is an exception and not a rule. And that's good.
I have some questions. Right.
Go on, Dan.
Thank you.
Go on.
Пане Ярославе, просто запитання.
So, Yaroslav, just a clarifying question. You're not the first candidate who claims that most representatives of the judiciary are people of integrity and are professionally competent judges. So thank you for this opinion, but don't you think that there is some controversy here between this statement of yours and the statement saying that courts are mainly not trusted? Or in case we have some polling and some surveys, normally courts and judges are at the lower positions of those rankings of trust. And also the statement that we need to have a reform of the judiciary. And the very fact that we have the interview, we have the selection process, these are the things that show that there is the level of dissatisfaction in the society with the work of the judiciary. You know, Ivan, I used to work in the prosecution for quite a period of time, and the prosecutor's office actually underwent the same process that we now are facing in the judiciary. I worked in the prosecutor's office for almost 20 years, and I would say that the situation is rather similar. I know a lot of prosecutors, most of whom are people of integrity, who have been working for the state, in the interest of the state, but some specific individuals have led to distrust. And that's why in 2015 I actually passed my decision to go to the armed forces, because I didn't see any other way out. I didn't know how to correct the situation in which we appeared, and I didn't see the prospect that the prosecutor's office would just undergo this cleaning process. That was a period of time when, unfortunately, a lot of prosecutors who were people of integrity left their jobs. I think that the judiciary cannot be deprived of its mandate the way it happened to the prosecutor's office. And I think, or I'm rather sure, that if some judicial bodies are deprived of some controversial individuals, that will come as a sign that will show other judges that even the salary that judges now have is a sufficient motivation to be staying at your job and not be looking for some additional motivation that would not belong to the reasons of integrity. So I can see that your answer contains some criminal law issues, but that is not the duty of the HQCJ to get rid of indecent judges. This is about the mandate of the High Council of Justice. Sorry, I didn't hear you quite well. Could you repeat? I just mentioned that it is the mandate of the High Council of Justice to make the system rid of indecent judges who are not people of integrity. Yes, I understand it. I understand it perfectly well that assessment can be made only in the form of the qualification assessment of a judge and through the development of the judicial dossier. So it's about people, right? Right. Well, not exactly. It's all both about the people and about the system of law. Stephen?
Let me just, please proceed.
It's
No, that's okay. If I have further questions, I'll get it next time.
Next round.
okay. So, у вас є деякі цікаві ідеї.
You've got some interesting ideas which you reflect in your motivation letter, and I would like to discuss those ideas with you.
Ви кажете,
You
що
claim
задля посилення
that in order, let me quote your motivation letter, to improve the independence of judges, you would initiate
професійних
that judges are elected out of professional lawyers, prosecutors, in particular at the regional level, and you claim that you are sure that if it happens in that way, that will contribute to personal involvement of judges in the adoption of legitimate and legal decisions. What do you mean by that? Do you mean that judges of trial courts should be elected for a certain probation period, because it's mentioned in a way in your motivation letter in this part? Ivan, if I could answer in a little bit different direction. The point is that I was writing the motivation letter when I was in the army. And unfortunately, I was rather formal about writing this motivation letter, and I expressed some ideas that left from my work in the prosecutor's office when we discussed with colleagues what could actually restore trust in the judiciary and prosecution office. Now, after I've got acquainted more with the situation with the judicial reform, I think that in case I'm elected a member of the HQCJ, my mission as the former NABU and ACPC worker would be to convey the messages and to bring them into life. I mean, I would not advocate any excessive changes in the judiciary, radical, drastic changes. But you have mentioned the databases. Is it really good to keep those databases abroad in the current situation? Well, you know, the world is changing so quickly that I don't see any major barrier on that way. We are all using VPN and all other means. And the State Information Protection Service, do you think that it will agree to that? Well, I'm not sure about that, but we will see. The situation is changing on a daily basis, and I know that a lot of bodies have been forced to relocate their databases. Well, probably not exactly through the state border, but we don't know what the situation is going to be. There is no pressing need for that now, but the situation is dynamic and changing. Thank you for your answer. I also support this idea that the databases should not necessarily be kept only in the territory of Ukraine. Yes, and I agree with this, and I think that it would be probably even more reliable to keep them in the European countries, but I think that we could discuss this issue in relation to the registry of declarations of the National Agency for Corruption Prevention, but this is a difficult topic, but probably it would be relevant. Yes, it's really a complex topic. So here is the issue not directly related to your motivation letter. And probably I will have to explain to our foreign colleagues what I mean by this term, but I'm just interested in it. You, as a professional, as a lawyer, as a prosecutor, a detective, from time to time, as I understand, face the term some of us call the paper army. What do you think on this paper army? And how do you manage, and whether you generally manage to overcome this problem? Well, Ivan, you know, this is the issue I could talk on for several hours. I don't manage to do this, actually, and I am frustrated about this situation. I hope that closer to the end of the war, we will manage to change the system. I know that the Ministry of Defense is now considering the issue of electronic document flow, and I think that this is the major first step that will help to at least partially improve the situation. Okay, thank you. Let's move on. Colleagues, who's got questions? Yevhen? Let me give the floor to my colleague, Yevhen Mezentsev. Good afternoon, Yaroslav. I'm Yevhen Mezentsev, and let me ask you several questions. First of all, let me express your gratitude, my gratitude to you for the compliment made by you. You said that integrity is exception and not the rule. I mean, lack of integrity is exception and not the rule in the judiciary. But again, that could be discussed for hours. You worked in the selection commission within the NACP. Yes, over a year I was involved in the work of the Selection Commission. Great. You mentioned that it was with your participation that more than 100 staff members of the National Agency for Corruption Prevention were actually appointed. Yes, that was the experience of 2021. Great. And what was the procedure like? And how much could this experience of your work come in handy in your work should you be appointed a member of the HQCJ? Since I was involved in the first stage of judicial selection in 2018, and my participation ended up during the first exam, where I got 75% of correct answers, the minimum possible score. And my work, well, the work in the NHCP and the procedure for selection there is pretty much the same. The people had to pass the test in the knowledge of legislation. Then there was a test for general skills and abilities, and after that there was the meeting of the selection commission that chose 3 candidates, and the chairperson had to choose one person out of them. So you seem to be a sober-minded and logical thinking person, so let me ask you 3 questions. And please give very specific answers, and not just that we should improve and we should establish, develop, and blah, blah, blah. Unfortunately, we can hear statements like this very often, but these are not answers. These are just general phrases. So here is the following question. You are a person with a new, fresh view of the selection procedures, and you are a person from beyond the judiciary, not related to the judiciary as such. So could you please tell us what 1 or 2 specific activities you would like to take right away if you were elected a member of the Qualification Commission of Judges in order to, in the direction of assessment of future candidates? What are the things that would promote a transparent and open selection? Well, I can tell you that the practices I have been facing up till now do not fully comply with the Supreme Court practices. I've got acquainted with the resolutions of the Grand Chamber of the Supreme Court, but now I understand that this work should clearly comply with the legislation. No, let me clarify my question. What is the activity step that would be of use? For example, polygraph testing, or increased number of testing, or IQ test, or maybe something else, some specific test that you would consider to be helpful for the selection of new judges. In fact, I've gone through all those tests, I've taken them, and my impression is that the test of general skills and abilities must be there, because it shows that it is efficient. As far as polygraph testing is concerned, I hope that it will come as a separate issue from you, a separate question from you. I don't think that this is a goal. It is a way, a method, which, as I think, does not correspond to the standpoint of the Supreme Court. So I don't think that polygraph testing would be an expedient thing to do now. We have discussed polygraph testing, and we have come across different ideas on that point. Okay, then let's discuss with you the opportunities for political engagement or political neutrality. This is also one of the key criteria according to which we are selecting the would-be members of the HQCJ. And this is one of the criteria through which judges will be selected and by which incumbent and future judges are to be assessed. It would be wrong to state that every single individual could be politically neutral. We could all be politically engaged because we are not indifferent about the life, about the processes happening in Ukraine and around us. Of course, we are following them, and of course, we support something or we object some directions, some movements, or even some concepts related to the state development. We have had a lot of discussions on what could be considered violation of the principle of political neutrality, like staying with a member of the party, being a member of the party, or some propaganda, or some support or statements to support a certain political party, the statements which are made in public. So could you specify where the limit is between acceptable political level of interest and the principle, the violation of political neutrality? Where is the limit after which the person goes beyond? What does a person have to do to really be considered not to be politically neutral?
Well, the most constant form of political process in Ukraine are the elections. I believe that the participation in the election process means that you are already participating in the activities of a specific political party, because you cannot be having any political engagement per se, even if you are a member of the elections commission. That's on the one hand. But on the other hand, we do understand there's influence of politicians on judges. And in this respect, it's difficult to work out a specific algorithm. I think that all suspicions should be voiced during the work of HQCJ, and the candidates should be given the opportunity to appeal such claims even in mass media, maybe do it in a different way, and then on the ground of the assessment of these facts, we can make a decision as to any political engagement, as to any political affiliations. So, if a person at the moment is not running for any office, is not involved in any other political activity through a political party, then we can say that they are practically politically neutral. But let's say some 10 years ago, a person participated in the elections 3 times, running from a specific political party, let's say a left-wing party. In your opinion, can in this case we say that the person is politically neutral? Well, I'm only expressing my personal opinion. I would say, for me personally, such a person would not be politically neutral. But as a representative of the state, I will have to use objective facts. So I will have to study the opinions of the Grand Chamber of the Supreme Court. So we will have to voice our suspicions, try and collect additional information through PIC and law enforcement bodies. Then the candidate judge or judge can explain these facts, and then we make the decision. Well, it's clear what the procedure is. Everybody is aware of the procedure, but I would like to listen to your opinion, but let it be. There's another question that I have. This is something that has been a concern of mine for quite a long time, and at the moment I don't even have my own answer for this question. The question is as follows. How can we prevent, not just for a judge, but for any public servant who has a level of influence, how do we prevent them from abusing their position? And how do we do it that with time the judge does not want to use their position for their own gain? Why am I asking this? Because there are specific measures that have been implemented recently, which I, as a judge, consider to be clearly positive. If we are talking about potential corruption in judiciary, that's automatic distribution of cases, the exclusion of the influence of administrative positions. That's really important. That is something that has yielded positive results. Plus, e-declarations, which are open. It also gives us an opportunity to trace the income, rather to follow the income, and make it less prestigious to accumulate wealth. At a certain moment in time, it was no longer fashionable to drive a Geländewagen, to own expensive Swiss watches, and demonstrate other attributes of wealth. And also, I believe that another important instrument is declaration of expenses, another effective tool, which is non-intrusive, as you mentioned, but it's a constant way to control everyone who is declaring their property and assets, it will mean that maybe it will not be safe for this person to buy another Lexus car because it will be already reflected in their declarations, and the civil society and the public in general will see that. What else? What additional measures, at least one, can you suggest that we could use to prevent judges from abusing their position, from benefiting from their position? Or maybe this could be an instrument that would prevent them from accumulating illegal wealth. I would not be focusing so much on the judiciary and judges while answering this question. Well, it is important for all the public servants because overcoming corruption only in the judiciary does not mean that we will not have any corruption at all. It has to apply to all the entire government bodies. But do you have another measure that you can suggest? Yes, we can limit transactions in cash, and we can have declarations for all individuals, not just for the public servants. Thank you. Robert.
Thank you, Robert Broekhuizen. Mr. Dukh, I'm sorry. My first question to you is, you're working now in the army, I understand, as a legal advisor. And I'm wondering what your view is, why the people in Ukraine see the army as the most trusted organization of Ukraine, and why the people in Ukraine see the judiciary as one of the least trusted organizations in Ukraine. And you have been working in connection with both of them, so you maybe have seen why this is.
I personally believe it's about the engagement of the public in this or that process. At the moment, hundreds of thousands of men serve in the army who are someone's husbands, brothers, and children, while on the other hand, the judiciary is quite separated. It's quite separated from the society. And that's why the society is being apprehensive about the activities of the judiciary. Plus, the consumers of the judicial services, because they are not engaged in the process of formation of the judiciary, they have no way to influence. They cannot really express that they don't agree with the opinions, and some cases of lack of integrity of judges is sometimes blown out of proportion.
Yeah.
That's my answer.
You do not believe that trust is earned?
Well, trust is earned. But we know how the judiciary works. Every day, the judiciary deals with hundreds of cases, convicts hundreds of criminals, but the society does not hear about it. People hear only about some notorious cases, about some violations, and the majority of information that is present in mass media is negative. It's about the connotation of the news. We are living in the information society.
But still, of course, you are aware of the fact that the European Union is contemplating to allow Ukraine to become part of it, but has certain conditions before that may happen. And those conditions are all related to corruption, the rule of law, and the judiciary. So apparently, the view of the European partners is different from your views in that respect.
I'm not stating that there are no problems in the judiciary, that there are no issues that we should be overcoming. But we do have an anti-corruption strategy and anti-corruption program in Ukraine, which is currently being discussed. We are agreeing on the specific measures. And I believe that the judiciary is no different from other state institutions. We limit discretion mandate. We clearly specify the mandate for other government bodies, and the same can be applied to the judiciary. And at the same time, as a lawyer who is constantly dealing with the application of law and procedure, I can tell you that our procedures are very complicated. They are too formalized, and this does not contribute to swift effects expected by the society and our partners. So maybe we could simplify our procedure and have more clear algorithms of the activities of courts.
Maybe I'm wrong, but being in this process, I keep on thinking, and again, maybe I'm completely wrong, because I'm just a foreigner. What do I know about Ukraine? That, let's say, it may help that if a judge is allegedly related to corruption, that immediate action is taken against the judge to make sure that he does not continue giving the decisions, but that he's taken out of the process, and that immediate investigations take place, whether or not those allegations are true. And if they appear to be untrue, that he's reinstated, and if they appear to be true, that he is removed from the system. What do you think about that?
Well, this mechanism is foreseen by the Ukrainian legislation, but what we see in reality is that investigators, even preparing documents on removing a judge, appear in courts, and the other judges do not support such decisions. It's about the integrity of all the judges in general and the attitude of judges towards their removal, towards the removal of their colleagues who lack integrity.
But if I'm frank, does this not show that the problem is a lot larger than the fact that there are maybe a few corrupt judges? Because if the system protects itself from attacks from the outside, it will never become clean.
Yes, of course, I've looked into the research done by the European courts. I've studied the judiciary reforms, and I know that the European courts try to remove corrupt judges. In Ukraine, the situation is different, but we can also not remove the guarantees for the activities of judges. That's why I believe that the anti-corruption strategy and its implementation will potentially solve the issue on how the people should be influencing the formation of the body of judges, where the limits of the influence of the society on the judiciary lie. But of course, we need to keep the guarantees for the judges as a special category of lawyers.
Well, I can, let's say, I cannot see in the future, but I can tell you that I expect that the European countries will say to Ukraine that you have to instate, let's say, rules and regulation that make sure that if there is any sign of corruption, immediate action is taken. And that, and my question to you is, let's say that you're a member of the HQCJ. Let's say that you have all the powers in the world. Because when I ask the question, often it is said, I don't know because I don't have the power in the HQCJ. But let's say that you have all the powers that you may have wished in your life as a member of the HQCJ. What would you do to raise the level of trust in the judiciary?
The mechanism of removing a judge who lacks integrity may be considered, but I think it's all about the organization of the activities of HQCJ. What is the most important is for the public to be engaged in the process, is for the public to hear about the procedures taking place. I don't want for you to take this as a very abstract answer, not precise enough, but the bodies of judicial self-government should respond immediately. But at the same time, I do believe it's the mandate of HCJ at the moment, not the mandate of HQCJ. And HCJ should request a dossier, should initiate integrity review of a judge, and should initiate a complete inspection of the documents available.
Mr. Chairman,
Well, I will just clarify your question, okay?
please go
it's-
ahead.
I don't know if the translation is okay. Я просто спробую, можливо, переформулювати
I will try
запитання
to
свого колеги.
reformulate the question of my
Відчуття,
colleague.
що,
It appears to me that maybe something was lost in translation. I don't know.
Мій колега Роберт теж працював
So my
довгий
colleague
час прокурором,
Robert
який-
used to be a prosecutor for quite a long time, just as you were.
Да, і боровся з корупцією.
Yes, and he was dealing with corruption cases, and here he is here as a member of the commission. So his question is about the following. Sometimes he asks the candidates,
Проблеми з корупцією там в суді, да, чи
if there are problems with corruption in court, and if there are some allegations of corruption, what would you as an individual do? And very often the candidates reply,
там немає повноважень,
well, I don't have the
якби
mandate,
це там повноваження там
or
ВРП,
this is the mandate of HCJ, so they are shouldering their responsibility. No, not shouldering their responsibility, but they are answering Robert's question within the realm of Ukrainian legislation. But his question is different. So if we forget about existing legislation and procedures, and for a moment imagine, let me formulate this in a way that is clear.
Не ВККС приєднується до ВРП.
So it's not the HQCJ that becomes part of HCJ, but HCJ becomes part of HQCJ, and we have amendments to the Constitution. The mandate of HQCJ is different. So you are a member of HQCJ, or whatever the name of that body is, and you have all the powers in the world. You have all the capacities, everything necessary
Розбиратися там або із конкретним
in order to
корупційним
deal
кейсом,
either with a specific case of corruption or
підвищення довіри до судової
in
системи.
order to enhance the level of trust in the judiciary. In a situation like this, what would be your specific behavior? What would you do? Dear Ivan, so if our society is ready to restore some form of prosecutor's office which would have this mandate, because in the late 90s and early 2000s we did have that mandate and we could respond in a way that Robert mentioned. So we could, for instance, request with the law enforcement or other government bodies to initiate criminal proceedings or to initiate an investigation to assess the behavior of this specific judge. And the body of judicial self-government would need to have some guarantees, not guarantees, but rights with regards to control of such an investigation. And at the same time, other bodies could check the circumstances that could either prove or debunk the allegations, like a check done by NACP with regards to property status. The State Committee of Financial Monitoring could provide information about their bank accounts. So I understand what the scope of actions could be, but it's the issue of availability of mandate with the bodies of the judicial self-government. And that's probably it.
Не помиляюсь, і це буде
if I'm not mistaken, it's going to be a remark and a comment to you and to Robert. It's our European partners who initiated the narrowing down of the mandate of the prosecutor's office and taking away this function of oversight, which it used to have. Thank you. Ted?
Yes, Mr. Duke. I have a great admiration for your work history and experiences, which I think will be very interesting should you be chosen as a member of the High Qualification Commission. We have asked a number of candidates to discuss the issue of integrity, and that's what I intend to do with you. If you would or should be appointed to the HQCJ, I would be interested in what approach you would encourage your fellow members of the High Qualification Commission to take with respect to the assessment of integrity of judicial candidates. You have, I think, a degree of familiarity with the HQCJ work and their approach to integrity. Integrity and the criterion are defined in their regulations. What either additional or special approach do you think is needed to successfully evaluate the integrity of judicial candidates?
I think the question is not about introducing something on top of the existing criteria, but me observing your commission, I'm really impressed with the depth with which you approach each candidate. The lifestyle of a person shows how they go about fulfilling their work obligations, whether they prefer the interest of the public or their personal interests. That is why the experience of the person, their property status, their involvement with the judiciary can already tell us how qualified they are and whether they have integrity. So any additional measures like polygraph testing or psychological tests are subjective and, in my opinion, will not be received as a form of control or inspection of integrity. That is why I would focus my condition on the profoundness of the study of candidates and their dossiers. The information provided by PIC and the law enforcement in particular, who as consumers of the judicial services are interested in having judges with integrity. It's not about the means, it's about the end goal. If everybody channels their effort towards achieving this end goal, then the activities will be effective. They will bring results. That's my opinion.
A related question. There are those who theorize or perhaps recognize that integrity cannot be proven. What can be proven on a reasonableness standard is a lack of integrity. Those circumstances that give rise to a reasonable doubt about a candidate's integrity. Do you agree with that observation?
I totally agree. Since we are selecting lawyers, I would first of all pay attention to their integrity during participation in court hearings, and I would also pay attention to the information available with law enforcement. I would also pay attention to the way in which the person was participating in the specific proceedings. So this could be an additional way to assess the activities of the person to prove their integrity, which, in my opinion, was not used up till this moment.
Thank you. Judge Verlanov?
Дякую, пане Ярославу. На сьогодні ви у нас
Dear Yaroslav,
перший кандидат.
you're our first
системи
candidate from the system of law enforcement.
Доречно задати вам запитання такого змісту.
That is why we need to ask you this question. Let me go back a little bit.
Як вбачається із ваших документів?
As can be seen from the documents received by the Commission, you've been working as a prosecutor for quite a long time. You were working for the Prosecutor's General Office, you were working at NABU, and you are currently working at NACP.
Скажіть, будь ласка, що конкретно вас
Could you please tell us
податися
what inspired you
членство у Вищій кваліфкомісії?
to apply for this competition to be selected as a member of HQCJ? I explained this in my motivational letter. Yes, you explained your motives. But what inspired you? What was your impetus to apply? The thing is that you're working in law enforcement, and then you saw that a judicial body is being formed, a body that will be selecting and assessing judges and will be operating within the judiciary.
Ви зараз вирішили подати.
And you have decided to apply. So what made you make this decision? In the year 2021, I was actively involved in the activities of a selection commission. It was quite an interesting experience for me, and I realized that I have acquired a sufficient level of skills and knowledge to apply them further. Also, I believe that the formation of a fair judiciary could be the peak of my career, and that is something that I would be interested in doing for the years to come. I was also dealing with cases of non-declaration, illegal accumulation of wealth. That's why I believe I have the competence to assess potential candidate judges and judges with respect to these things, even should some information about them be concealed.
Дуже дякую вам, пане Ярославе.
That's clear. Thank you. Thank you for your answer, Yaroslav. Now your motives are more clear to us. And my next question
Будучи, свої наміри,
is as follows.
будучи членом ВККС, наміри
So, as a member of HQCJ, you already told us a little bit about what you plan to do to enhance the level of trust in the judiciary. But again, could you be more specific?
призначення вас членом ВККС,
Let's imagine you have been appointed as an HQCJ member.
якихось етапів
So,
підвищення.
what would you do to enhance this level of trust? In my opinion, there should be two factors here. The first one is for us to involve the PIC in the activities of HQCJ, of course without violating the guarantees for judges. Maybe they should have an advisory vote, or maybe they should have the right to veto as it used to be. Maybe one member from PIC could be a member of HQCJ. I don't know. Maybe I have not yet studied the recent developments, but I do believe that what we are currently discussing requires amendment of the legislation. But still, we need to enhance the level of transparency in all of the procedures of HQCJ. The public should know about the decisions made, the decisions should be communicated to the public, and the other users of judicial services should also be aware of these decisions and procedures. We also need to discuss together with them. There should be public discussion of the legislative framework as a way to overcome lack of trust in the judiciary. And in your opinion, what are the key problems
Сейчас взаимодействие саме ВККС.
in the interaction between PIC and HQCJ?
Well, they have failed to establish any cooperation. The truth is always somewhere in the middle. You just need to start the interaction from scratch to determine the clear rules of the game. And you know, the anti-corruption program that is currently under discussion suggests some activities in this field. Primarily, this is about determining the criteria of judicial assessment and judicial candidate assessment. And in this specific case, the PIC will clearly understand what the criteria are and what information should be collected for the HQCJ. And already this stage will provide some understanding, will ensure some understanding. The other stage is of involvement of the PIC concerned, well, if their opinions are not taken into account, that automatically that will definitely lead to a lack of cooperation. Within the selection process, I was telling you about, we didn't have any conflict with the PIC. We just came to some consensus on all candidates.
Дякую вам.
Thank you. Clear.
Пан Стівен.
Stephen?
Thank you, Judge. Thank you again, Mr. Duke, for going through this process. I do think that Judge Verlinoff has asked a very important question. It may be an obvious question, but it's an important one still. Why have you applied in this process? I've been trying to figure out during the course of this discussion what your motivations were, and the tale that you tell in your motivation letter kind of has an ending that I didn't expect. When you said that mostly you were disappointed in the judicial process in your years as a prosecutor, I guess I understood that as a hint or suggestion that you would be more on the side of transformation or upheaval or change on the High Qualification Commission. But that doesn't seem to be the case. I mean, I listen to you and I see you being on the side of stability and the status quo. You say that you do not favor excessive changes, and I guess excessive is the $64 question in that statement. You think lack of integrity is the rare exception. You think that the lack of integrity has been blown out of proportion. You see discipline of judges who act inappropriately and even corruptly as being the task of their colleagues in the internal disciplinary process. And you have a lot to say about databases and document flow. If I'm summarizing your overall attitude unfairly, I hope you'll correct me, but I'm just trying to decipher your approach as I do the approach of all the people who are participating in this process. You almost see a tension between the approach over the years of the NACP and what's at issue with the new and perhaps not strengthened High Qualifications Commission. But again, maybe I misunderstand you there. So I do think that Judge Verlinoff's question that I mentioned at the outset remains to me a good one. Why did you apply? I'm not sure what transformation of the High Qualifications Commission you see as being necessary, and that's fine. Maintaining the status quo is an entirely reasonable reason why anybody might want to be on that agency, but I think Mr. Brookhuizen is correct in some of the things he says about the European Union, and I think many of our applicants have been focused upon change and transformation more than maintenance of stability. But I've shared my thoughts with you. Is there anything that I'm badly misunderstanding in terms of your situation and thinking about membership on the HQCP?
Well, Stephen, you know, my recent experience still shows that I'm on the side of transformations and I'm ready to accept all transformations. But, you know, I used to work for 18 years in the prosecution. I went to court quite often and I'm respectful about guaranteeing the court activity. So changes really need to be introduced. But what I mean is that they should be clearly understood. And they should not be just general changes in all the elements. I don't think that any specific method of assessing judges, if we're talking about polygraph testing, should be the objective of the judicial reform. That is just a method, but the objective is to restore integrity of the judiciary. So I think that the forms and methods could be discussed. But as a team player, I would like the methods suggested by the civil society organizations to be also perceived well by the judiciary, to be suitable for it. Because I remember the reform of the prosecutor's office, and I don't think that this reform was really something good for the prosecutor's office.
Well, they're not entirely perceived.
At least in terms of the performance of the prosecutor's body's performance.
Let me say to you that changes in the High Qualification Commission are not entirely perceived well by the judiciary as far as I can see it. And restoration of integrity seems to imply that there do be changes in terms of the procedures and the questions and the standards and the processes that are applied, and maybe the qualification assessments need to be strengthened. Otherwise, what is the means by which we restore integrity and we address corruption? So even in that answer, I'm a little confused by whether you do favor transformation or you don't. And I'm not suggesting one is better than the other, but I'm just trying to understand what changes, if any, or what maintenance of procedures would Mr. Dukh effect upon the High Qualifications Commission. And I'm still understanding that you would be a force for the status quo, which is not dishonorable. Of course it's not. But I just ask you, is that a fair characterization again?
I think that we should introduce more of digital control. That could be the change. And this digital control could be both in the qualification assessment of judges and in the arrangement of selection procedures. Because now the procedure presupposes a lot of paperwork, paper component in the assessment of judges and their qualifications. And this makes this assessment more subjective. The other component of changes is the issue of integrity and its assessment. To my belief, adequate assessment of integrity using all available information will enable us to ensure changes in the judicial staff the society is waiting for. And available information was not disposed of properly by the previous composition of the HQCJ, I would say.
Okay. Well, thank you again, Mr. Dukh, for your participation. And of course, thank you so much for what you're doing on behalf of your country. You really are a patriot. Thank you. Mr. Chairman?
Dear colleagues, do you have any more questions?
Yes, I have.
No doubt.
Пане Ярославе, ну давайте подивимося на
Yaroslav, let's have a look at this situation with judicial impartiality from a different point of view, from a different angle. From the point of view of vision of judges themselves. Of course, for every judge to pass a well-balanced decision, comprehensive, well-thought-over decision on the basis of their rule of law and the norms of the law and on the basis of his own beliefs, it's important to eradicate any pressure on the judge. So the judge should be separated from any pressure or intention of exerting pressure. What do you think? We have now the system of addressing the High Council of Justice with some claims concerning the attempts to exert pressure on judges. Could you somehow comment upon this situation and probably give some recommendations or just give some thoughts concerning how we could arrange the system of protection for judges against external influences, how we could make the system more efficient? Well, you know, it's a little bit difficult for me to give the answer to this question. Since 2016, I have not been involved in such processes. All the more, it seems to me that the legislation which presupposes responsibility of the attorney at law for abusing his rights actually limits a lot of lawyers in terms of this abuse. Well, yes, the procedure for the judge to address the High Council of Justice with the statement that there have been attempts to exert pressure on him, it may take time, but you have to consider the case within a certain timeline. So would you suggest anything, any components or elements through which we could actually protect judges from any external influences for it to be more effective? In fact, it seems to me that now the more of e-court we have, the more the actions of everyone will be well documented and obvious and evident. So it seems to me that this direction will also help the judiciary to be more independent. Okay, thank you. Because abuse of power and of rights would be limited in that way. Thank you. I've got your concept. Thank you.
No further questions.
Yaroslav, so our interview is about to conclude. Please do sum up it. Do sum up the interview. Maybe you still want to say something you haven't yet mentioned, or you want to draw our attention to some core things, core ideas of yours. What would you tell us as a wrap-up? It seems to me that my experience and background tells even more about myself than the words I could now tell. But I would like to draw the attention of the Commission to the fact that within a year I have not been dealing with any legal activity. And maybe I've lost my communicative skills partially over this period of time. But as a person who used to be a member of the Selection Commission for a year's time, I would like to indicate that I've already got some positive experience thanks to your work, and I like your questions very much, in particular your questions, Yevhen. Your questions are always deep, and I've got acquainted with the practice of the Grand Chamber of the Supreme Court, and I have paid attention to Article 19, or Part 19 of Article 79 of the Law on the Judiciary and Status of Judges. So thank you for enriching my experience. And thank you, dear members of the Commission, for your questions and for your deep and profound study of all candidates. My experience is positive, and whenever I am involved in hiring some staff, part of the experience is accounted to you and to your work and to your questions. Thank you, Yaroslav. So let's consider it to be the end of our interview. Good luck. Stay safe. Goodbye. Thank you. Goodbye.